speaking of another lawsuit, oh, I've been putting it off and putting it off and putting it off and putting it off. I guess I'll go ahead and talk about it. Guess who else is going to the appellate court? Can you guess who else is going to the appellate court? Can you guess what couple is now headed to the appellate court? You said Kenya. You said Simon. You said Dr. Simon. Yes, it's Dr. Simon to you. Simon Iore, okay? Simon is headed to the appellate court. Simon said you was not going to take my money in my house without a fight, okay? Now, just a couple of weeks ago, everybody was reporting that Porsha had won. Porsha had won, and Simon was, they claimed that Simon was ordered to pay Porsha's legal fees, and of course, we pulled up the motion. And while the judge did say, that they were moving on from the prenup fight, the judge did rule that Porsha has to pay her own legal fees. And here is actually that order. Okay. Now, I'm gonna go ahead and read a little bit since we in here. Okay, this was the first order. Okay, and I think we read this one, but we got some more. We got about 3-4 orders to read. So sit back, grab a piece of coffee or something. But here is what all of the blogs were running with. Okay, because Portia's attorney drafted an order. This is the order. This is what they were asking for. A preliminary overview is what the wife or the petitioner was asking for. The petitioner was asking for the court to grant wife's motion to quash the husband's subpoena to True Entertainment. They were asking to grant wife's motion to quash the motion for protective order. They were asking the court to deny the husband's emergency motion to compel mandatory and additional discovery. They were asking for the judge to deny husband's emergency motion for contempt of standing order. And they were asking the judge to award wife attorney's fees. Now, this motion tells you exactly what the court decided to do. Now, the court did grant, decided not to go into, not to allow Simon to depose True Entertainment. So this is all the background. We ain't gonna go into that because we've been doing it. But they granted all of that. They did quash Simon's request. Here it is right here for True Entertainment LLC for a subpoena for production of evidence. They were saying no. Actually, the judge didn't feel that was necessary. Okay. Wife argues that given the existence of a prenuptial agreement that has not been deemed unenforceable, it appears to be valid on its face. This court should not allow any discovery. So the judge sided with the wife on that and said, okay, well, since you saying that the prenup said that, then I'm gonna grant it. Okay. But okay, towards the end of this order, these are everything that the judge ordered. Accordingly, this judge grants wife's objection to motion to quash husband's subpoena to True Entertainment LLC and orders that the husband subpoena to True Entertainment notice of deposition, blah, 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 blah. So be quashed. So he's saying, we're gonna stop that. How all of that. That's what the judge did. Now he also denied the husband's emergency motion to compel mandatory and additional discovery. So basically, he's not allowing the husband to look into any of the allegations that he was saying. He wanted to look, to depose some witnesses. He wanted to pull bank records. He wanted to do all of that because he felt that, the prenup was signed under, false pretenses. Now, towards the end, the court, was saying this court finds that there's no evidence that the wife engaged in willful conduct in violation of the court's standard order and further finds that there is no evidence to substantiate that wife acted in bad faith, blah, blah, blah. That's the judge's order. And then it also says this court hereby denies husband's emergency second motion for contempt of standing order. And also this court hereby denies wife's request for attorney's fees. Y'all see that down at the bottom? Signed by the judge. So some of y'all have been reading the actual sample of the order instead of the actual signed copy of it. Okay, the draft. I'm sorry, not the sample, the draft. So here is the actual signed copy. Now, I get so tired reading legal papers. I just want to go lay down. Yes, like this video, please. Thank you. Like this video. Okay. People say it's 1,400 of y'all in here counting Facebook. Well, 1511 counting Facebook. Thumbs up over there on Facebook. Okay. Wait, we are not finished. So Simon decided that he didn't feel like that was fair. So he's using his vast amount of wealth, like Porsha said, he used his vast amount of wealth to file additional documents, basically saying, I feel like this isn't right. Hold on. So Simon filed a request for a certificate of immediate review. Hold on. And we have it. Request for certificate of immediate review. Simon said, not so fast, Judge. I'm going all the way. I take it all the way to the appellate court. So Simon filed these documents right here. Comes now Simon Guobadia responded in the above style action by and through his attorney, wherein the court granted petitioner's objection to and motion to quash respondent's subpoena to True Entertainment, granted petitioner's motion to quash, motion for protective order, and denied respondent's emergency motion to compel mandatory and additional discovery, and denied respondent's emergency second motion for contempt of standing order. This and he states the following. On September the 12th, the court entered the order that I just showed you, where they granted all of Porsha's wishes, denying everything that Simon was asking for. Okay, y'all see that? The court allowed petitioner's objection and motion to quash, respondent subpoena to True Entertainment LLC, and petitioner's motion to quash and motion for a protective order to be heard, and the motion granted, and the court granted the motions through the petitioner failed. Although the petitioner failed to meet the condition of precedence under OSCR, blah, blah, blah. So this is Simon's argument saying basically, it's not right that you are not allowing me to get evidence to dispute, yes, quash, to dispute this prenup, okay? And I have tried over and over and over again to let you see that this is why I'm asking, for these records. So in this request, he's saying that he wants the judge to agree to allow him to move on to the appellate court, child, to have an emergency review. Okay. So he's saying he did all of that. He attached the witness affidavits. He did everything that he was supposed to do, but the court still granted petitioner's objection and motion to quash respondent subpoena to True Entertainment. He's saying all of that. He was saying that when there is a prenuptial agreement at issue and a divorce, the facts at issue are not limited to only financial information. He also referenced the case Alexander versus Alexander, where he says that in determining enforceability of prenuptial agreements, the question is not whether there was a misrepresentation or a failure to disclose financial information. The question is instead a broader one, wherein the Shearer test requires a trial court to determine whether there has been a full and fair disclosure of all material facts by the parties entering into a prenuptial agreement. So Simon said that Porsha was not forthcoming with the information before he signed the prenup. He said, who initiated the divorce? Porsha. Porsha initiated the divorce. Simon is accusing Porsha of entering into this marriage under false pretenses, of actually staying married just long enough to trigger the prenup and walking away with his $7 million house and a settlement. That's what he's saying. I'm saying we've been reading these court documents for so many months, and probably gonna be reading them for a few more years. So now he's going through what he feels like the issues that the court did that were not fair and legal. Okay, he was saying he has the right to review those things if he was going to dispute the prenup. So he entered all of this. He said the court also allowed, over respondent's objection, the petitioner to qualify Edward E. Bates Jr. Esquire as an expert witness and testify at the August 21st motions hearing, although the expert witness was not previously disclosed by the petitioner. So he is like, listen, listing his claims for appeal. He said further, the quandary, the court simultaneously quashed the discovery served by the respondent that would have allowed the respondent to discover the petitioner's expert witness and adequately prepare for the expert witness, including any defenses thereto. Whew, child, this is a lot, honey. So basically, it's saying by doing so, it deprived the respondents of due process as of the August 21st, 24th hearing, and was never formally noticed for a hearing on the enforceability of the prenuptial agreement, let alone noticed at all. So he's saying the court made several mistakes. And number 10, he said, as the Supreme Court of Georgia has explained, the constitutionality guaranteed right to due process of law is at its core the right to notice and the opportunity to be heard. Neither the federal nor the state constitution's due process right guarantees a particular form or method of procedure, but is satisfied if a party has reasonable notice and opportunity to be heard and to present her claim or defense, due regard being had at the nature of the proceeding. Blah, 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 blah. So this is 9 pages. So he's asking them to for an immediate review. The aforementioned questions are of such importance to this case that immediate review should be had by the appellate courts. Based on respondents' extensive research of Georgia law, some of the questions presented appear to be questions of first impression. Also, an immediate appeal would assist this court and the parties because it would allow for a timely, definitive ruling on the issue before the case progresses. So this is Simon's request, okay? He requests for immediate review. Now, of course, Porsha filed a motion disputing this, saying, he is not entitled to do that. Don't do it, Judge. Don't do it. That's what Porsha's saying. Don't do it. So Porsha, you said she already lost having to pay those attorney's fees. Exactly. Listen, they both losing when it comes to attorney's fees. Nobody's winning except for the lawyers and the judge. Like, they getting paid for their time. Simon and Porsha are not. But anyway, so Porsha actually filed a response and basically said, listen here, Judge. This man has a lot of money and I want it. That's what Porsche said. This man has a lot of money and I want it. And because I've been trying to get this money, I stayed for a year, and he said that if I stayed for a year, I could get this money and I could live in this house. However, you just ordered that, I could, that the situation was closed. So she's saying, comes down Porsha Diane Williams, petitioner in a above style divorce action. Okay, she's saying wife shows that husband's request made on or about September 12th lacks merit and fails to demonstrate any legal error or sufficient grounds for warranting appeal. She's saying he don't need no appeal. What I need to appeal for? The request is made to impose further delay in this case and to harass and prejudice wife. Further, wife shows that it is within the court's sound discretion whether to grant or deny the request. Moreover, this court has indicated that a hearing on petitioner's emergency motion to enforce the prenuptial agreement, which could bring this case to a prompt end, is forthcoming. Additionally, there is no urgency to grant husband's request, especially considering the likelihood that husband has and will continue to appeal any unfavorable ruling issued in this divorce action. Porsha saying he gonna keep appealing. So it's no reason to do it now because he gonna appeal it anyway. So she's also saying husband's request is not based on any substantive legal issues, but is instead yet another attempt by husband to abuse the litigation process and avoid accountability for his ongoing pattern of bad faith litigation. Wife further shows that husband's request ignores the court's instructions, mischaracterizes the facts, and attempts to relitigate issues that have already been resolved. Moreover, Husband's failure to provide the agreed upon red line revisions to the proposed order demonstrates his ongoing bad faith and obstructionist behavior. Child, Porsha wants Simon held for contempt if it's up to her. So she's saying that, everything that the court has decided thus far that has been in her favor should stand. She don't see why it needs to go to the appellate court. She doesn't understand. She's citing various cases of law where, it's literally the judge's discretion. She said, lastly, and most importantly, broad discretion is given to the trial judge in determining whether I can't speak. Application is appropriate. The statute provides no clearly delineated specifications or ascertainable criteria for the appellate court to review the decision of the trial judge. So she's saying there's no reason to go to appellate court. I don't understand. Why is he doing this? She's saying husband had the opportunity to provide the court with red lines revisions, which should have been included, but he didn't do it. He didn't do all the things he could have done. And now she's also saying by forcing the wife to respond to baseless objections and stalling the resolution of the proposed order, husband's actions are intentionally driving up wife's attorney's fees, placing additional stress on her as punishment for seeking divorce. So clearly, Porsha has to pay all this money and Simon is driving up the fees, and now going to appellate court is going to further strain her pockets, because clearly he ain't paying for her attorney's fees, because I just showed you that. Whew, this is juicy. So number 7, while the wife shows that she has no legal burden to demonstrate that husband's request should be denied, she nevertheless shows as follows. Husband will suffer no prejudice in waiting until the conclusion of this case to appeal. She said he need to wait. He don't need to appeal now. It is no urgency. She's saying husband is solely requesting a certificate of immediate review to cause further unnecessary delay and increase wife's attorney's fees and expenses of litigation. Now, here's the key. If Simon was paying, if he had been ordered to pay, she wouldn't care. But clearly, since she got to pay her attorney's fees, time is of the essence. We don't need to do that, because I don't have no more money to be paying for these attorney's fees. That's what Porsha is saying in her motion. She also says she will be greatly prejudiced if husband's request is granted. So there's all that. So she's basically asking for a judge to say no. So wherefore, wife respectfully requests that this court exercises broad discretion pursuant to all applicable Georgia law and deny husband's request for certificate of immediate review. And see. Now, what do y'all think happened? What do y'all think the judge did? Do y'all think the judge was on Porsha's side again, ruled in Porsha's favor? Do you feel like the judge said, well, you're right, Porsha. He doesn't have a right. He's not a citizen anyway. He don't have a right to fight for his property and his money. He don't have a right. What do y'all think? Y'all think the judge denied it? Put a 1 in the chat if you think the judge denied it. Put a 2 in the chat if you think that he granted it. Let me know what you think. The judge is where the money resides. Oh, you think they denied it? Oh, grown woman think they denied it. Okay, Carla said they granted. Aaron said they granted. Okay, you think it's going to the pit? Okay, let's see what the judges said. We got the order. Hold on, let me pull it up. Here's the order from the judge. It's signed and everything. The judge said that he is going to grant it because Simon has every right to fight for his property. That's what he said. If he willing to pay these legal fees, then he can go over there to the appellate court and another judge can look at it. And if the other judge sees something that I didn't see, and that's on them, okay? So here it is. The court having entered an order on August 21st, motions hearing on September 12th, wherein the court granted petitioner's objection to and motion to quash, blah, blah, blah. The court hereby certifies, in accordance with provisions of OCGA 5634, that the order is of such importance to the case that immediate review should be had in the Court of Appeals of Georgia. Accordingly, the court grants respondent a certificate of immediate review regarding its September 12th order. Ooh, child. Ooh, child. That's what happened when you have money, honey. You can keep filing until you get your desired result. Oh my God, this is a mess, honey. I don't know what Porsha got herself into. He said Simon needs to let it go and move on with his life. Why he need to let it go? He and that lady ain't got no children. They ain't got no children. He feel like she tricked him. Okay. And if that's how he feels, that's how he feels. If he's going to get the right judge, if he keeps playing, okay, well. They all in this together. Poor Porsha. Poor Porsha. It was Porsha's decision to file. So how is it poor for Porsha? I'm confused. I'm confused. Simon did not file for divorce. Simon is only playing opposition. I'm just saying. He's playing offense. He's trying to get his house back. That's what I'm saying. You said, good. I'm happy for Simon. Get her. Ooh, you said Porsha is wrong. Simon is too much. Listen, I don't know. This is not my fight, but it is interesting to see what is happening in the situation. She came for the wrong bag. Okay, she got a little bit of it. She got to stay in the house for a little while, rent free, mortgage free. She don't have to pay no bills for as long as she there, and she's basically squatting until the judge decide it's time to go. But there's that. So salute to Simon and Porsha. Hopefully they'll get it together.